Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland and Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
Welcome to Win with the Law. Learn how to navigate the legal landscape and end up on top with the help of the legal community's most prominent lawyers. My name is Gary Newland, a trial lawyer with Newland and Newland LLP. We will discuss issues involving the law and strategies for success, so those listening can be empowered to achieve successful outcome when it comes to legal challenges. Without further ado, I'd like to introduce Erin Adamski. Ms. Adamski is a partner in the law firm of Newland and Newland LLP, and she practices in the field of personal injury. Welcome, Erin.
Thank you, Gary.
Erin, I believe you and I are going to discuss what's involved in a personal injury case, and we're going to focus on discovery, specifically what is involved with answering interrogatories.
Yes.
Okay. So when someone comes in and they hire a personal injury attorney, if a matter cannot be resolved without filing a lawsuit is filed in court. Is that
correct?
What you understand?
Yes. If we're unable to reach a resolution pre-litigation, we need to go to court. That doesn't mean we're going to go all the way to trial, which is a common misconception. It just means we're entering into litigation. And answering interrogatories is part of discovery, which is the first stage in litigation.
And sometimes we know, depending on who the insurance company is or the type of injury it is, that they're not going to settle amicably, and we just go right into litigation at that time. Is that right?
That's very common. There's a lot of reasons that we need to go into litigation sooner rather than later. It could be because of the insurance company involved. It could be because we have a very large injury involved and we need to proceed to litigation sooner. It could be because we don't know who all is involved and we need to proceed to litigation. For example, in slip and fall cases, if we have a client who's injured at a store, we don't always know who's involved beyond simply that store. Somebody else might own that premises. There might be a cleaning company, a maintenance company, a delivery company. There might be other parties we don't know of. So there's a lot of reasons we would need to proceed into litigation instead of trying to resolve amicably without litigation. It doesn't mean we're not going to continue those efforts. It's just sometimes the best interests of the client are served by going into litigation sooner.
Now, at our firm, at Newland and Newland, we prepare every case as if it's going to trial, because that's the only way you can get respect from the insurance companies. Is that fair?
Absolutely accurate. That's why we have a whole team working on the case. So the attorney is always preparing to go into litigation while simultaneously medical records are being collected. We're maintaining contact with the client. There's always more than one front and more than one path being pursued. So we're ready at any given time to file that lawsuit if need be.
So the first stage is filing the lawsuit. The next stage is getting service of process, correct?
Correct. And one thing that clients, I'm frequently presented with the question from clients is why there's such a big gap there. What a lot of personal injury individuals don't understand is that they've been involved from the start, right? They got injured. They know what happened. The defendant doesn't always know what happened, let alone their insurance company. So we're going to file a lawsuit. Then that lawsuit needs to be served on the defendant. Then there needs to be a first court date after service. So there can be 45, 60, even longer number of days between when you file the suit and then that first court date. So there's a big gap in time there because the defendant not only needs to be informed, they have to update their insurance company, and they have a right, obviously, to retain an attorney, just like the injured party. So there's unfortunately a large gap of time once you file the lawsuit.
It's kind of like a jigsaw puzzle wherein the insurance company or the defendant has certain pieces and we have certain pieces. And if we put all the pieces together, then it gives everyone a clearer picture of what's happening with the case. Is that a good way to explain it?
Yes. I always explain to my clients, unlike the TV shows you watch, trial is not supposed to be a surprise. It's not supposed to be shock and awe. You should be presenting a fair, accurate picture. And how you do that is by putting all of those pieces together and by discovering all of the information involved. So that's why we're exchanging information throughout the process.
And that exchange of information is called discovery. And one element of discovery is interrogatories.
Yes, that is
So,
part of the first. Yes.
can you explain what interrogatories are?
So, sure. So, interrogatories are, like you said, they're a part of the discovery process. They're the first part. They're just like what they sound. They're interrogatories or questions each side asks of the other party. So, in a personal injury lawsuit, the defense obviously needs to know about the injury. So, they need to know from the plaintiff or the injured party what your injuries are, sometimes a little bit more about how, for example, if it's a slip and fall, how you fell, where you were when you fell. If it's a motor vehicle collision, the defense or defendant is going to know where you were because they were involved in it. If it's a slip and fall, they might not know what part of the store, what part of the property, so they might need to know a little more information. They also need to know how it affected your life. That's going to be a huge category, but you can break some of it down in interrogatories. They need to know if you missed work. They need to know if you have any other individuals who might have been with you that saw what happened. I mean, there's so many questions they're going to ask you in the beginning, but what it's boiling down to is them asking you questions. We are doing the same of the defendant. I always remind my clients that I know this seems like a lot of questions for you to answer, but rest assured, the defense is answering a lot of questions also. They're just answering different types of questions.
And the court limits how many questions each side can ask of each other in the initial discovery process, correct?
Correct. The Illinois Supreme Court rules not only limit how many questions, they also limit the types of questions. So they can't be overly intrusive into your privacy. The questions have to have relevancy, or they have to be related to the personal injury lawsuit. They don't get to go back, for example, in your medical records, they can't go back to your birth. They can't know everything that's ever happened to you in your life. But if you're claiming you injured your knee, they get to know if you've ever injured your knee before. That has relevancy because is this a new injury or is this an aggravation to a prior injury? So they get to know certain things, but the court does limit it so that you're not going to be feeling like, how come I'm injured, yet I'm the one who has to not just meet a burden of proof, but I'm the one who has to expose my whole life. So it's a working process that we go through with them.
And each question in the interrogatory is like another piece to the jigsaw puzzle for both sides to put together so that we can all better understand the strengths and weaknesses of our case. Is that
It
right?
is. It is. And it's really important that everything in those questions is fully disclosed so that when my client tells me what's going on, I can put the whole picture together for me. Sometimes a client isn't even aware that they haven't told us something until they've been asked it in a question. So these questions are very important, not just to put that whole picture together for the defense, but also to put the whole picture together for us so that we see something that in full cooperation, the client might have just accidentally not mentioned to us that now we know.
It's common issue that comes up is oftentimes a client will have chiropractic treatment in their past, and that might be related to a minor injury they have. But an interrogatory question will say, "Have you had any prior medical treatment for any prior injuries?" And they don't tell us about the chiropractor because they didn't think much of it. But we need to know everything, so we don't get it doesn't get inferred that we're lying to them, right?
Right. That chiropractic and physical therapy are the most common. They think they've never injured that body part before, the body part that they're claiming they injured in this whatever we represent them for in this litigation. Because they've had just physical therapy or just chiropractic therapy. So they don't think they've ever injured it before. And I understand that thought process. I do. But we still need to know about it. So whenever I tell my clients, here's discovery to answer, I always remind them, please be thorough because I can't help you if I don't know about it. And I specifically list out anytime you've complained to a doctor of that body part, anytime you've slept wrong, you went to the doctor and said this hurts, you went to the physical therapist, you went to the chiropractor, you got dry needling, anything. I need to know about it. not saying it's going to hurt your case, but it is going to hurt your case if I don't know about it. So
That's interesting, and that brings to mind something. It's very important that we know everything because then we can handle damage control, right?
yes, yes. I always remind them the whole reason you retained an attorney is for us to handle the difficult situations. If it was simple to handle, you wouldn't need us. So you have to tell me everything that happened so that I can handle it. I'm not saying that this is going to ruin your case. This is going to bar your recovery. I'm saying that if I don't know about it, how can I do my job? So when you go to the doctor, if you tell them your knee hurts and you forget to tell them, oh, by the way, 4 years ago, I had 3 months of physical therapy, they can't do their job because now they know you had a knee injury before. It might not be a big deal, but it might be. So you would be sure to tell them that, right? You would fill that out in the questionnaire. Well, that's why these interrogatories are kind of our form of a questionnaire. It's okay that you might have forgotten before. We're all human, but now these interrogatories are going to hopefully spark your memory, or as we say, refresh your recollection, so that we can have a fuller picture as well.
The worst thing I think we can have is when we get surprised and it looks like you sign off on these interrogatories, the client does, saying it's truthful, that the answers are truthful. So if they don't give us all the information, then the other side gets to talk about how they were trying to hide something and they lied under oath. Is that sometimes what you
Yes.
see?
Yes. And the interrogatories, when you sign them, you're attesting that they're true and accurate to the best of your knowledge, memory, recollection. So I don't want to say there's an out, but like I said, you're human. It's okay. But if you forgot about, I don't know, 2 weeks of chiropractic treatment 8 years ago, probably not going to hurt your case. You forgot about 6 months of physical therapy treatment 2 years ago. Okay. Why didn't you remember that? That was a little bit more substantial. So we need to probably assess that.
And you know, and then where we have issues too, it's they had that physical therapy, but they also had an MRI they didn't tell us about. And oftentimes, when we're told more, it actually can help the case even more because if we have the prior MRI, we can compare it to a current MRI and oftentimes show the injury.
Which is, again, the whole point. You just never know where it's going to go. So let us explore that for you. And that's the other thing. We're talking so much about prior injuries. That's just one subset of an area that we could learn about in answering interrogatories. There's a question I mentioned earlier, the Illinois Supreme Court advises what can and sometimes what can't be answered. Well, one of the common questions is, were there any witnesses? The police report in a motor vehicle collision indicates witnesses the police knew of. But when you go through and answer interrogatories as a client, you might remember, oh yeah, you know what? This woman did approach me afterwards. And you know what? I think she gave me her business card. You might have forgotten that because you were in pain, because it hurt, and you didn't think of that until you were asked again. So it's not always just prior injuries or prior treatment. Other things can come up too. So these questions, it really is important to have as much information as possible, for better or for worse.
No, that's great. And that's true. So lay it out for your attorneys so that they can help you answer the questions best. One of the things is, what's the process? So the defense sends these interrogatories to us. And then how does your office manage that once they're sent?
Right. So they're going to send them to us. What I look at everything that comes through my office. So I'm going to look at the interrogatories and I go through and write notes for my clients. They seem like a lot of questions. They're usually 30. The Illinois Supreme Court limits them to 30. If the defense asks 31 or 32, okay, it's fine. I go through these interrogatories. It looks like I said, a lot because there's 30 questions. So I go through and write notes for my clients. For example, you don't need to provide your employer's name, where you worked, if you're not claiming lost wages. If you're retired, that's not relevant for you. You can skip that question. You don't need to provide us all of the doctors you saw and all of the bills that were generated. My paralegals already discussed that with you. You could ignore that question. I do need to know what you're claiming you injured. I know that you feel you've told me that, but I need to know that in your own words. My clients always think they have gone over this with me. You have, but it's very important that I know, because that is the number one deposition question. What are you claiming you're injured? And that's the next part of discovery, which we're not getting into right now. But I put notes on the questions so that you see not only what you're supposed to answer, but what I'm telling you you need to spend the time on answering. I send these questions to you along with an email saying, dear Mr. and Mrs. whatever, attached, please find the discovery to be answered. Please go through and answer every question. Don't skip anything, because then I don't know if you didn't understand it or if you accidentally skipped over it. So please go through and answer everything. Right? I don't know if you don't know. Contact me, contact my paralegal, reach out to us for anything. I also follow up this email with a phone call. I emailed you discovery to be answered. Let me explain to you what this is. I want you to verbally understand it. I followed it up in writing and I sent it to you to be answered. It seems like a lot. It's not. You're going to sit down and write it and it's going to come back to you very quickly. Most of the time, my clients couldn't forget these facts if they wanted to. And sometimes they want to. They wish they couldn't remember this. So it's going to come back to you, but I want you to hear it out of my mouth. I want you to read it in writing, and then I want you to sit down to answer it. So by the time you're answering these questions, you don't feel like I just threw a softball at you. You feel like you knew what was coming. You're comfortable with what was coming. So the questions you have after that, you really just don't understand it, and that's fine. And that's when you come back to me and say, okay, I still need help with this, or this.
So, as lawyers, we do our best to keep track of all the medical providers our clients have, but it's also important for them to keep track as well. I think one of the most common questions we have, or one of the biggest issues we have to deal with, is we're trying to accumulate all that information as to all the medical providers because we have to give it to the other side. And our clients leave medical providers off. And some of that's because what they don't remember, right? That's typically the situation, but it's very important. So everything from where you had your MRI to the surgical center you may have used to any therapist you saw, and all that stuff has to be disclosed. And again, if we leave something off, then they can be interpreted as that we're not telling the truth. We're trying to hide something.
So that's why I try and
And
break
so
it
what
up into separate things. Here's the interrogatories. Separately, we create a list of claimed medical specials so I can go over it with them in a chronological order separately from the list of questions. Otherwise, it can feel like a lot. It can feel like a lot of things to answer. It probably feels like a lot to anybody just listening. When you go through it, it doesn't, because like I said, you lived it, you remember it. But to try and articulate all of it sitting down with pen in hand or typing, figure of speech, it feels like a lot. So we separately go through the list of treaters, who you saw, when you saw them. And I remind my clients, I'm going to do this more than once. I'm going to do this more than twice. We're going to go over this multiple times. My paralegals are going to call you. I'm going to call you. It is vital to your case, nothing short of vital, that we leave nobody out. So we are going to go over this with you multiple times because we can't mess this up. And they always laugh, and then they realize, yep, we go over this multiple times because I need to know every time you saw your doctor. I need to know when you followed up with your doctor. So I remind them, not only will I go over this multiple times, but that's your only burden. That's your only burden in hiring an attorney. You keep up with your treatment and remind me as you go. That's your job throughout the case, to remind me what you're doing.
and it's very, very important to remember that if you did leave someone off, it's okay. Just let the lawyer know as soon as you can, so the lawyer can address any issues and reduce any potential negative from leaving something off. And usually, almost all the time, it's very fixable.
Yes, it
So
usually is. We have the right to supplement. So I can disclose not only somebody you've left off, but maybe your treatment just continued from when you answered discovery. You've just seen more doctors since. I can supplement discovery and provide ongoing treatment, but I can't give ongoing information if you don't give it to me. So just open lines of communication.
the insurance companies and their lawyers are also, they have all the resources in the world. They're insurance companies, they own all the buildings downtown. So they're looking at our answers and researching them to see if they're right. And so if we say, we haven't been in any prior accidents or something like that, the insurance company has database they can look at to see what other accidents you were in. So there's all sorts of methods they have that they can use to help verify what we're saying. For example, let's say you have to use a cane now since the fall, and you tell us, hey, I never leave home without my cane. Well, you can be sure that they're sending someone to videotape you at the grocery store or wherever else to see if you have a cane. So when you say things like, I never go out without my cane, you got to mean that. It's got to be real. It's not really, it was only 75% of the time I use my cane. Well, no, then you're set up.
So oh, my apologies.
No, please go on.
I was going to say that's the big difference between answering interrogatories and giving a deposition too, which is an entirely different form of discovery. When we answer interrogatories, 99% of the time, I will remove statements like that because 99% of the time, my client didn't mean it. And they're not trying to lie. They mean they use their cane a lot, but they don't mean they use their cane all the time. Or when they say they can't sleep on their back anymore, they always have to sleep in a chair. They don't usually mean always. When they say they can't go grocery shopping at all anymore, well, they just mean they can't carry really heavy groceries probably. And they're not trying to be deceptive. They're trying to paint how their life has changed. And they mean grocery shopping has changed. Sleeping has changed. My walking abilities, my gait, my ability to play with my dogs, those things have changed. That's what they're trying to convey. They're not trying to be as intense as those sentences are. So I usually remove those sentences and then call my clients and say, I'd like you to review the final version. And they always review the final version and then sign, and that's what I sent. And they usually don't even recognize that I've removed those intense sentences.
Yeah.
And then when we prepare for the deposition, then I remind them, you had mentioned this. Would you like to mention that in the deposition? Now let's prepare for that a little bit more now that you're orally giving testimony.
And that's true, because part of the process is you answer the interrogatories and then they do your deposition and they ask you questions about your answers to validate things and to understand more, to put other pieces together so they can complete the puzzle. And so that's why it's important.
And
it's interesting. I'm sorry, go on.
Oh, I'm sorry. That gives a better opportunity too, because then if you say, I always use my cane, the defense attorney would say, always? Really? And then you can say, well, I mean, most of the time. Then it's more, it's not conversational, but you have the ability to control what you're saying.
And they're looking for someone to say, I always do something, and then they'll have someone hiding in a bush outside the house videotape them taking out the garbage, and they won't have a cane with them. And then, and then they attack our clients that way. And just because they took a risk and didn't use a cane that one time, sure enough, that's when the guy's in the bushes.
And it's just really unfortunate because nobody always does something. It's just human nature. You're just going to forget.
Yeah.
So that's why I do that. And I remind my clients when they're answering interrogatories or responding to requests for production, which is the other thing that goes along with interrogatories. You answer questions. You also provide materials. I remind my clients when they're doing both of those things, you're going to give the answers. My paralegals are going to review your answers. Most importantly, I'm going to review your answers. I'm going to insert objections. I'm going to respond appropriately when they might be being overly intrusive. And I'm going to look at things like that. When the defense is not entitled to this information, or maybe just not entitled to the information yet, I will review things like that. You will get a final version from me before it goes out to the defense for those exact reasons. So you don't put yourself in a hole.
And typically what they'll do is they'll bring those interrogatories to your deposition. And even though you already verified under oath that it was accurate, they'll ask you to do that again at your deposition.
Yeah.
Because they want to find something inconsistent so they can say, oh, you didn't tell the truth when you filled out the interrogatories, and you didn't tell the truth at your deposition. So how do we know to believe you now? And that's how they try and set you up and affect your credibility.
Yes, anything they can do to attack your credibility.
And it's an adversarial process. Insurance companies are trying to save as much money as they can. And the court system has these rules that kind of make things more fair for both sides. People always say things about the trial lawyers, and really it's the trial lawyers don't own the buildings downtown, and the trial lawyers don't control the legislature. It's the insurance companies with all the trillions of dollars that control the laws. We just come into this process and we try and create a little equity. We try and make things more fair so that we can maximize your outcome. That's our job. And we know the rules. And Erin, your experience now, you've handled way over 1,000 personal injury cases in your career. And can you tell our listeners what types of cases you handle most often?
Yes. So most often are slip and fall cases and motor vehicle collision. That's a really large category, though. So motor vehicle collision can include what you think of, two cars. It can be a pedestrian. It can be a bicyclist. It can be a large truck. A truck and tractor trailer are how they're appropriately referenced. Personal injury can also include dog bite cases. We have food poisoning cases. We have allergic reaction cases, which are different than food poisoning, similar but different. When you, as an individual, put the restaurant or the school on notice of your allergy and you're not treated appropriately or properly with regard to that allergy. We handle a lot of municipal cases, which encompasses any of those harms that I just spoke of. It simply has to be handled in a very delicate matter because you're dealing with a city or you're dealing with a city owned or city sponsored entity, the park district or a school or things like that. So it's when you're caused to suffer an injury by another person, and we will take on not only the injury but any derivative of that injury. So if you're a minor, we will help you through the probate process as well. If unfortunately your loved one passes away from that injury, we will help through the probate process. We will help from start to finish, I guess is the point. We'll get you through the entire process. Most commonly, it does involve the large motor vehicle collisions, the slip and falls in premises, meaning inside of a building, outside of a building. I think that pretty much covers it. Those are the most common ones that we handle, the ones that I see most of the time.
Yes, I think it's fair to say, though, you really do all types of personal injury, though, and
Yes.
it's these are just more common injuries than others. I think, and one of the things I wanted to bring out, because you are an artist when it comes to trip and fall and slip and fall cases in terms of maximizing our clients' outcomes, because you know the rules so well and the issues in those areas of the law. Um, can you tell our listeners um, what is your secret to handling these types of trip and fall and slip and fall cases?
Well, if I told them, it wouldn't be my secret anymore. So probably.
So
I
I
think
think it's really an eye for detail, isn't it?
yes, it is. It's an eye for detail. As far as my clients go, if you are injured, if it is a slip and fall injury, be it on a substance inside of a property or ice or a trip and fall on a curb or a hole or a divot or anything along those lines, slip and fall covers all of these things. I really want to stress it is really important that you seek an attorney as soon as possible. I would love it to be us, but the important thing is seeking an attorney as soon as possible. There are more parties involved than you realize. So let us get in, let us start that research as soon as we possibly can because we want to make sure that you don't have any statute of limitations issues. We want to make sure that we uncover video as soon as we possibly can. We all know the presence of social media is everywhere. That also means cameras are everywhere. So we want to preserve that footage as soon as we can, and that it overwrites, it expires. So the sooner you get to an attorney, the sooner they can capture that footage. That can apply in motor vehicle collisions, but it applies most often in slip and falls. Also, beyond those 2 points, the slip and fall, trip and fall law is very particular. there are a lot of nuances to it. You should not be blamed because you were distracted by something else, because you were going about your life. I don't want to say you can't argue it yourself. I just want to promote that we do know how to argue it. Let us help you so that you can focus on what we mentioned earlier, getting the treatment you need. You focus on that. Let us argue with the property owner. Us argue with the city of Chicago. Let us argue with the store. Let us deal with that so you can focus on being able to walk properly again, helping your shoulder rotate fully again. You deal with that and let us fight this part.
Erin, that's really interesting. A couple of points I want to bring up along those lines. You had mentioned the concept of distraction, and some people are like, "Oh, it was my fault. I was distracted. I was looking at the flowers when I should have been looking at my feet in front of me and the water on the floor." Well, you have to understand this process, and the process is oftentimes the stores are intentionally trying to distract you, so that doesn't go to their favor. They're trying to get you to look elsewhere, and they're also at the same time having certain trip hazards in front of you. So they shouldn't be profiting because they're having you look somewhere else other than where, a trip hazard exists. So that's one of the ways Erin
Yes.
maximizes some of the injury cases is she uses the issue of distraction to the benefit of her clients.
It happens all the time. They don't realize how distracted they were by the beautiful display. And they're saying it as they talk to me because the store did exactly what they wanted to do. They achieved their goal in distracting their customer. That's good job, store. But this is what happened. And it's not just stores. You can have a very attractive flower setup and display outside of a condominium association, and therefore people aren't looking down. When was the last time you looked down as you're walking? Probably when you were a year and a half and learned how to walk. So unless you're looking at what your dog is doing, if you're walking your dog, you're probably not looking down. You're probably looking at the beautiful flower display that the condominium association wants you to be looking at. So distractions aren't always inside of stores. But again, you would think it's your fault and you might not even call an attorney. So it's really important to call us as soon as possible so that we can help you from the start.
Yeah, another thing along those lines, and I would say the past couple years, for some reason, it's been getting worse. It's you would think some of the major businesses in our community and in our region and in the country would be honest about things that happen. But we just, from a major retailer in the Chicago area, we just got awarded attorney's fees because of their dishonesty in a case. And the past couple of years, stuff like that has been happening more so. And you can't expect insurance companies and large corporations to tell the truth and to want to do what's right. So that's why we're here. We make them do what's right. And we're here for you. Erin, thank you for explaining interrogatories. And thank you for explaining to us your expertise. And the reason I focused on fall cases is because I know they're a passion of yours. So thank you for explaining that.
They're a huge passion. I always think of Jerry Maguire, help me help you. Just be honest. Be honest. Help me help you. I don't want to say fix it, but we can do the best we can with it if you tell us about it. Just tell us. We are here to help you. That's why we're plaintiffs' attorneys, not the big insurance company attorneys. We want to help you. So tell us about it and let us do our job.
Yeah, and sometimes what you think doesn't help you actually makes the case. So that's for us to figure out.
Right.
With respect to things, I want to thank you for being here, Erin. I want to have you back to spend some time explaining what production in more detail to our listeners. What we covered today was interrogatories. So with respect to things, we're signing off. Thank you for joining us, everybody. And we look forward to our next podcast.
Thank you, Gary, and we'll see you all soon.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.